Bring honestly provocative talk everywhere you go. Search iTunes for the Lars Larson Show podcast.
Welcome back to the Lars Larson Show. You might have heard this development a day and a half ago about the lawsuit involving families of the victims of the Orlando gay nightclub shooting. They filed a federal suit against Twitter, Facebook, and Google for allegedly providing material support to the Islamic State and helping to radicalize shooter Omar Mateen. They filed it in the Eastern District of Michigan. The families of Tevin Crosby, Javier Jorge Reyes, and Juan Ramon Guerrero, arguing that the three social media platforms provided the terrorist group ISIS with accounts that they used to spread extremist propaganda, raise money, and attract new recruits. Well, I thought I'd talk about the legal issues of this with Byron Henry, who's an attorney at Scheef and Stone, LLC. He's also a constitutional scholar. Mr. Henry, welcome to the program, and in advance, thanks for coming on, and Merry Christmas to you and yours.
Merry Christmas to you. My pleasure, Lars.
I got to tell you something. As much as I hate the whole Islamic State movement, I'm really reluctant to say I could support the idea of suing any kind of media, like Twitter, Facebook, Google, like talk radio or cable news, for merely transmitting information this way. Am I off base here?
No, in fact, not only you're not off base, but the Communications Decency Act, the so-called, well-known Section 230, which provides a safe harbor for these platforms, basically gives a platform immunity as long as it is just a conduit or a pass-through for the transfer of information, sort of like the phone company. If you wanted to go back before we had Facebook or Twitter or whatnot, if people used a telephone to make calls in a conspiracy to actually, blow up a building or commit terrorism, you couldn't sue AT&T, or the electric company for using their utilities. So likewise, there's a protection for these platforms. Now, the catch is they have to be truly pass-throughs. They can't be part of the conversation. They could only be a platform, so they can't interject themselves and use this or create new content or spin it in certain ways. So that's really the catch here, and I think the lawsuit is trying to blur the line on just them being a pass-through of information versus them actually taking an active role in promoting this content and trying to make money on it by pairing advertisements with it. And I think that's the catch this attorney from Michigan is trying to use. Not so sure it's going to work out, but that's the distinction in this case.
Well, let me ask you about the distinction, because I could see an objection. For example, I'm a gatekeeper for media, to some extent, for my own media. So every once in a while, somebody will call the show, especially during a contentious presidential election, and they will threaten one of the candidates, or they'll threaten the president, either the sitting president or the president-elect. And it's my job to make sure that threat never makes it to the air. And so far, we've been successful because I decide, whether or not we're going to let that on the air. And if I do let such a threat on the air, I've never had it happen, but I would have a visit from the Secret Service because it's a federal crime to do that. But that's actually talking about a threat. In the case of Facebook, are they a little bit different because Facebook actually does make qualitative decisions about which things that you post end up going through and being displayed to other people? And I mean, there are algorithms that do that, and I think there's even some human screening. I know that some of the social media will screen through photographs, and I think there was a case recently where one of them got in trouble because there was a famous nude picture of a painting or a piece of art that a lot of us would have recognized it as art, but apparently they'd farmed it out to a company, and the young lady or young man who screened that one thought it was dirty and took it down. So they're involved in active gatekeeping of the content. Does that make them more liable?
Well, there's the rub, of course. If they announced recently, as you may have heard, that they're going to get together and create this joint database where they try to catch this pro-terrorism or facilitation of terrorism posts. The YouTube's part of that as well, and try to get that information off the internet or off their platforms. The problem with that is we want them doing that. Okay, let's just say
I agree. Well, maybe we do.
Then again, what if they do not succeed? In other words, they make a qualitative judgment that something is not terrorism, and it ends up being terrorism or leading to a terrorist act. Then we're going to hold them accountable for at least trying to do something. And I think the real catch here is, at least in this lawsuit, is just how much of a pure pass-through is Facebook, Google, and Twitter based on these algorithms, based on the fact that they pair advertisements with certain similar news and similar posts so that they get the most out of the advertisement to the targeted audience. I think probably from what I've read so far that they're probably not actively promoting or facilitating this information. They are a pass-through, but we're going to have to continue to test the limits of this so-called immunity for these platforms. And the more and more they get involved, as you said, with human screeners, some censoring. Some people say they're actively promoting certain trending topics, keeping Trump, for instance, during the presidential election out of the trending topics because they didn't want to push President Trump. If they're going to get in the business of being a content provider, not just a facilitator, they're going to decide what people see, then you might have a different argument under that statute.
Well, and let me ask you this. You know these cases better than I do, but there have been cases where people have given even relatively small amounts of money to charities that ended up being backers of terrorism. And the law, as I understand it, is if I give $100 to some organization that says we plan to even send medical equipment or medical supplies to, say, a terrorist organization, giving material support to terrorism is a federal crime in this country. So if they pass through that information and allow people or encourage people or facilitate people gathering donations for terrorist causes, it sounds like that might actually put them over the line, wouldn't it?
It could, but of course, for most criminal statutes, federal or state, you have to have scienter, or that you have to actually have knowledge. You have to intend that it go to not to terrorists, meaning the money you spend was designed to go for medical aid. That's not the knowledge I'm talking about. You have to know that the group that you're sending it to, even for medical aid, is likely to use it for nefarious purposes. It's not like I can write a check to a church and then 2 years later, it decides to go rogue and bomb an abortion clinic, and now all of a sudden I'm on the hook because I gave money to that church. But usually there is some connection, and it's sort of a known or should have known type thing where people, you know it when you see it, that it's well known, or they should have known that the money they were giving was being used to for whether it's for overhead purposes or other purposes to facilitate terrorism. Here, I think that we've got to be very careful saying they knew or should have known, even though I'm not, like I say, I'm not against suing media conglomerates for negligence or recklessness in reporting or doing things. I'm not against that per se. But as a facilitator of information, I've been on the radio before denouncing their censorship and they're deciding to take certain things down. That's not really hate speech; it's just conservative speech.
So have I.
And so I'm very leery of forcing Facebook and Google to start parsing what they consider terrorism, because some of people that I might listen to could be considered too radical to have on Facebook or Twitter.
No, I'm completely with you on that, Byron, because I'm concerned about them deciding that if I start talking about self-defense and buying guns, that somebody will decide that somehow crosses the line and is, aiding and abetting terrorism. I don't want them to do that. And I would think with hundreds of millions or billions of users, how in the world would anybody screen all of that data sufficiently? I can do it one-on-one with you. I actually had a law professor the other day drop an F-bomb on the air, and we caught it before it got there. And I said to the professor, Professor, you can't, and he was quoting a famous free speech case. I think it was blank the draft. And he said, well, I'm just quoting a Supreme Court case. And I said, yeah, the FCC does not differentiate. So, Byron, it's a pleasure as always. Keep up the good work, and I'm glad for your conservatism, and have a wonderful Merry Christmas.
You too, anytime, Lars.
Very good. Hey, you think that Democrats and liberals never come on this program? Well, Congressman Adam Smith, who is a full-on Democrat and, believe me, a full-on liberal, he's coming up next right here on The Lars Larson Show.
The Lars Larson Show.